I was standing in my backyard, drinking my morning coffee, when I noticed something that made me drop the mug straight onto the grass. Through the trees at the edge of my property, I could see construction equipment, workers, and what looked like the framework of a building going up on land that I was pretty sure belonged to me. My name is Isaac Harper, and I had inherited this 3-acre property in Greenville, South Carolina from my grandfather about 5 years ago. The house sat on the front acre, and the back 2 acres were mostly wooded, sloping down toward a small creek. I had always planned to maybe build a workshop back there someday, but life got busy with my job as an electrical engineer, and I had never gotten around to it. The land was just peaceful, quiet mine. Except now, apparently, someone else thought they could use it. I walked through the woods, following the old deer trail I had used since I was a kid visiting my grandpa. The sound of hammering and power tools grew louder. When I emerged into a clearing that had definitely not been there last week, I saw at least a dozen workers swarming around the foundation of what looked like it was going to be a pretty substantial building. There was a concrete slab already poured, framing going up, stacks of materials everywhere. A man in a hard hat noticed me approaching. "Can I help you?" "Yeah, you can help me by explaining what the hell you are doing on my property," I said, trying to keep my voice level. He looked confused. "Your property? This is HOA land. We are building the new community clubhouse." HOA land. I am not even part of any HOA. This is my land. It has been in my family for 40 years. The foreman pulled out his phone and scrolled through some documents. According to our permits and the survey, this lot is designated as community property for the Meadowbrook Hills HOA. We have all the proper authorizations. Meadowbrook Hills, that is the development on the other side of the main road. I am not part of that, he shrugged. "Look, man, I just build what I am told to build. You need to take this up with the HOA board. I have a contact number somewhere." He fumbled with his phone again. I took the number, my hands shaking with anger. This was insane. I had the deed to this property. I paid taxes on it every year. There was no way this was legal. As soon as I got back to the house, I called the number. A woman answered on the third ring, her voice cheerful and professional. "Meadowbrook Hills HOA, this is Brenda speaking." "Hi, Brenda. My name is Isaac Harper, and there are construction workers building something on my land right now. I need to speak to whoever is in charge immediately." "Oh, you must be calling about the new clubhouse. It is going to be such a wonderful addition to our community. We are very excited about it." "It is on my land," I said, enunciating each word carefully. "My private property that I own." There was a pause. "I am sorry, sir, but there must be some confusion. The clubhouse is being built on designated HOA common area land. Let me transfer you to our president, Patricia Morrison. She can explain everything." Another pause. Some hold music that sounded like it was from an elevator in 1985, and then a new voice came on the line. This one was sharp, clipped, and radiated authority in that particular way that women named Patricia who run HOAs seem to have perfected. "This is Patricia Morrison. I understand you have some concerns about our clubhouse construction." "Concerns? Lady, you are building on my property without permission. That is called trespassing, and possibly a few other crimes I can think of. Mr. Harper, is it?" "I assure you, everything is completely legal and above board. The land where we are building was part of the original Meadowbrook Hills development plan filed with the county in 2018. It has been designated as common area for community use. In 2018. I have owned this land since 2019 when my grandfather died and left it to me, but my family has owned it since the 1980s, long before your little development even existed. Patricia sighed in that condescending way that immediately made my blood pressure spike. "Mr. Harper, I do not know what to tell you. Our legal team vetted everything thoroughly. We have surveys, permits, and county approval. Perhaps you are mistaken about your property boundaries. I am not mistaken about anything. I want you to stop construction immediately, or I will call the police." "That is certainly your right, though I think you will find that the police will simply refer you back to us since this is a civil matter. But please, feel free to waste their time. In the meantime, our construction will continue on schedule. We have a very tight timeline to meet. Have a nice day, Mr. Harper." She hung up before I could respond. I stood there, phone in hand, trying to process what had just happened. This woman, this Patricia Morrison, had just essentially told me that she did not care that I owned the land, and she was going to keep building anyway. The audacity was breathtaking. I did call the police. A deputy came out about 2 hours later, took my statement, looked at the construction site from a distance, and then basically told me exactly what Patricia had predicted. "This is a property dispute, sir. You will need to handle it through civil channels. If you have a deed and they are trespassing, you should contact a lawyer." So that is what I did. Finding a good real estate attorney in Greenville was not hard. My buddy from college, Derek, was a corporate lawyer, and he referred me to a woman named Jennifer Caldwell who specialized in property disputes. I met with her the next afternoon. Jennifer was in her 50s, with gray hair pulled back in a bun and glasses that she kept adjusting as she reviewed the documents I had brought. I had my deed, my property tax records, the original survey from when my grandfather had bought the land, and every piece of paper I could find related to the property. "This is pretty straightforward," she said after about 20 minutes of reviewing everything. "You clearly own this land. The deed is unambiguous. The legal description matches the survey. You have been paying taxes on the full 3 acres. I do not see how the HOA could possibly think they have any right to build there. So what do we do? First, I will send them a cease and desist letter. That is the formal legal notice that they are trespassing and must stop immediately. If they do not comply, we file for a temporary restraining order to stop the construction, and then we move forward with a lawsuit for trespassing and whatever damages their construction has caused." "How long does all that take?" Jennifer grimaced. "It depends. If they are reasonable and stop when they get the cease and desist, maybe we can resolve it quickly. If they fight it, we could be looking at months, maybe longer if it gets complicated." "They are not going to stop," I said. The woman I talked to on the phone made that very clear. "Then we will make them stop. Let me draft this letter today. I will have it sent by certified mail and email by tonight." True to her word, Jennifer worked fast, but Patricia Morrison's response was just as fast and just as infuriating. She replied to the cease and desist with a letter from the HOA's lawyer, a guy named Richard Bennett from some firm in Columbia. His letter basically said that the HOA stood by its position that the land was part of the development, that they had done their due diligence, and that they would not be stopping construction. The letter also included a copy of a survey that supposedly showed the land as part of the Meadowbrook Hills development. When Jennifer and I looked at it, we could immediately see the problem. The survey was wrong. It showed property boundaries that extended well beyond what the development actually owned, encroaching onto my land by about 1.5 acres. "This is either incredibly sloppy work or deliberately fraudulent," Jennifer said. "We need to get our own surveyor out there immediately to document the correct boundaries." She hired a licensed surveyor named Tom Mitchell, who came out the next day with all his equipment. I walked the property with him, showing him the old survey markers that my grandfather had pointed out to me when I was a kid. Tom found them, noted their positions, and spent the next several hours taking measurements and checking everything against the official county records. His report confirmed what I already knew. My property line extended about 50 feet past where the clubhouse was being built. The HOA was not just slightly over the line. They were significantly trespassing, with the entire building on land they had no right to use. Armed with this new survey, Jennifer filed for a temporary restraining order. We had a hearing scheduled in Greenville County Court for the following week. In the meantime, the construction continued. Every morning I woke up to the sound of hammering and power tools. Every day the building grew more complete. It was maddening. The day of the hearing arrived, and I put on my best suit and met Jennifer at the courthouse. We were in front of Judge Robert Henshaw, a man in his 60s with a reputation for being no-nonsense and fair. Patricia Morrison showed up with her lawyer, Richard Bennett, who was exactly what I expected. Mid-40s, expensive suit, slicked back hair, and an attitude that suggested he thought this was all beneath him. Patricia herself was a tall woman with blonde hair that looked like she had spent an hour on it that morning, wearing a designer suit and enough jewelry to make it clear she had money. Judge Henshaw called the hearing to order. Jennifer presented our case first, walking through the deed, the tax records, the original survey, and Tom Mitchell's new survey. She had blown up copies of the surveys that showed clearly where the property lines actually were versus where the HOA thought they were. "Your Honor, this is a clear-cut case of trespassing," Jennifer said. "Mr. Harper owns this land. He has owned it for 5 years, and his family owned it for decades before that. The HOA is building a substantial structure entirely on his property without permission. We are asking the court to immediately stop construction and order the HOA to remove the structure." Judge Henshaw looked at the surveys carefully. "Mr. Bennett, what is your response to this?" Richard Bennett stood up, adjusting his cufflinks. "Your Honor, the HOA acted in good faith based on a survey commissioned by the development company when Meadowbrook Hills was first established. We had no reason to believe the land was not ours. We have invested significant resources into this project, and stopping now would cause substantial financial harm to our community members. Good faith does not override property rights," Judge Henshaw said. "If you built on the wrong land, that is your problem, not Mr. Harper's. With respect, Your Honor, we believe there are questions about the accuracy of both surveys. We would like to request time to commission our own independent survey to verify the true property boundaries." Jennifer jumped in. "Your Honor, this is a delay tactic. The county records are clear. The original survey markers are still in place. There is no genuine dispute about where the property line is. The HOA's survey is simply wrong." Judge Henshaw leaned back in his chair, thinking, "Here is what we are going to do. I am granting a temporary restraining order stopping all construction on the disputed property until this matter can be fully litigated. Mr. Bennett, you have 2 weeks to file a formal response to Mr. Harper's complaint. We will schedule a full hearing at that time. If you want your own survey, get it done before then." Patricia Morrison actually gasped. I saw her lean over and hiss something to Bennett, who put a hand on her arm to quiet her. "Your Honor, we request that the restraining order not take effect for at least a week to allow us to secure the construction site properly," Bennett said. "It takes effect immediately," Judge Henshaw said. "Court is adjourned." Walking out of the courthouse, I felt victorious for the first time since this whole mess started. The construction would stop. They would have to face reality, except they did not stop. The next morning I woke up to the same sounds: hammering, power tools, voices. I threw on clothes and ran through the woods to the site. Not only had they not stopped, but they seemed to have doubled the crew. There were at least 20 workers now, and they were moving fast, clearly trying to get as much done as possible. "What are you doing?" I shouted at the foreman, the same guy from before. "There is a court order stopping this construction." He looked uncomfortable. "I just got orders to keep working, man. They are paying me, so I am working." I pulled out my phone and called Jennifer. She was furious. "They are in contempt of court. I will file an emergency motion immediately. In the meantime, call the police again. They are violating a court order now, which is criminal." This time, when the deputy came out, he actually did something. He spoke to the foreman, who called someone, and within an hour the site was empty. The workers left, but the building was nearly complete. It had walls, a roof, windows. It looked like a real clubhouse now, sitting on my land, mocking me. Jennifer filed the contempt motion, and we were back in court 2 days later. Judge Henshaw was not happy. "Mr. Bennett, would you like to explain to me why your clients ignored a court order?" Bennett actually looked flustered for the first time. "Your Honor, there was a miscommunication. The construction company was not properly notified of the restraining order in time. As soon as we became aware, we stopped all work immediately." "A miscommunication," Judge Henshaw repeated, his voice dripping with skepticism. "A miscommunication that conveniently allowed your clients to substantially complete their building before stopping. It was not intentional, Your Honor. I do not care whether it was intentional or not. Your clients violated a court order. I am holding the Meadowbrook Hills HOA in contempt and fining them $10,000. If there is any further construction, I will increase that fine and consider criminal sanctions. Is that clear?" "Yes, Your Honor." Patricia Morrison looked like she was going to explode. Her face was red, and she was gripping the armrest of her chair so hard her knuckles were white. The next few weeks were a blur of legal filings. The HOA hired a new surveyor, who unsurprisingly came back with the same findings as Tom Mitchell. The property line was exactly where I said it was. The clubhouse was entirely on my land. There was no ambiguity, no gray area, no room for interpretation. But the HOA still would not back down. Bennett filed a response claiming that even if the land was technically mine, they had established an easement by mistake, or adverse possession, or some other legal theory that Jennifer said was complete nonsense. They were throwing everything at the wall, hoping something would stick. "They are desperate," Jennifer explained. "They have already sent out notices to all the HOA members about the new clubhouse. They have been collecting increased membership fees to pay for it. If they have to tear it down, they are going to have a lot of angry homeowners asking where their money went." "That is their problem," I said. "Absolutely. But it explains why they are fighting so hard. Patricia Morrison has probably told everyone what an amazing job she is doing, and now she is facing a massive failure. She will fight to the end rather than admit she was wrong." The full trial was scheduled for 2 months out. In the meantime, the clubhouse just sat there, complete but empty. The HOA had apparently planned a big grand opening, which they had to cancel. I heard through the grapevine that there was a lot of anger in the neighborhood about the delays, with residents demanding to know why they could not use the facility they had been paying extra fees for. Then things got weirder. I started getting letters in my mailbox from the HOA. Not official legal documents, but actual printed letters on HOA letterhead, signed by Patricia Morrison, demanding that I pay HOA dues and fees. The first one claimed I owed $300 in monthly dues, plus a special assessment of $5,000 for the clubhouse construction. I threw it in the trash. The second one, which arrived a week later, said I was in violation of HOA bylaws for not maintaining my property to community standards, and that I was being fined $500. The third one threatened to put a lien on my property for unpaid dues and fines. I took all of them to Jennifer. Can they do this? No. You are not part of the HOA. You never signed any agreement with them. They have no authority over you or your property whatsoever. This is harassment and we can use it in court. Should we do something now? Let them keep digging their hole deeper. Every letter they send just helps our case. But the letters kept coming. Patricia Morrison seemed to be on a mission to either force me to pay or drive me crazy. She sent me a notice that my grass was too long. A notice that I had unauthorized vehicles on my property, which was my own truck and my motorcycle. A notice that I was in violation for having firewood stacked on my land without HOA approval. I ignored all of them, but it was infuriating. This woman had built on my land without permission, and now she was trying to tell me how to live on my own property. Then the harassment escalated beyond just letters. I came home from work one day to find an orange sticker on my front door declaring my house in violation of HOA standards and demanding immediate compliance. I tore it off, but another one appeared 2 days later. Someone from the HOA also apparently drove by my house regularly, taking pictures. I caught a woman in a silver Mercedes parked in front of my house with a camera pointed at my property. When I walked toward her car, she drove off quickly. Jennifer sent the HOA a cease and desist letter demanding they stop harassing me. But if anything, it seemed to make Patricia Morrison more determined. She sent me a letter responding to the cease and desist, claiming that my property had actually been annexed into the HOA boundaries years ago, and that I was legally obligated to follow all HOA rules. It was complete fiction, but she seemed to believe it. She has gone off the deep end, Jennifer said. I have dealt with difficult HOAs before, but this is extreme. She is so convinced she is right that she is ignoring reality. Finally, the trial date arrived. It was a bench trial, meaning Judge Henshaw would decide rather than a jury. Jennifer said that was actually better for us because property law could get technical, and judges were usually better at handling those details than juries. The courthouse was more crowded this time. Apparently, word had spread through Meadowbrook Hills about the trial, and at least a dozen residents showed up to watch. I recognized some of them from the neighborhood. They did not look happy with me, which was ridiculous since I was the victim here. Judge Henshaw called the court to order. We are here to resolve the property dispute between Isaac Harper and the Meadowbrook Hills HOA. Mr. Harper is asking the court to declare that he owns the land where the HOA constructed a clubhouse, and to order the clubhouse removed. The HOA disputes the property boundaries and claims various rights to use the land. Let us proceed. Jennifer presented our case again, but this time in much more detail. She walked through the entire chain of title for my property going back to when my grandfather purchased it in 1982. She showed tax records, surveys, county maps, and aerial photographs from different years, showing that the land had always been separate from the Meadowbrook Hills development. Tom Mitchell testified about his survey and explained how he had found the original property markers and verified the boundaries. He was thorough and professional, explaining in terms that anyone could understand why the HOA's survey was wrong. Jennifer also introduced all the harassing letters I had received from Patricia Morrison, arguing that they showed the HOA knew they were in the wrong and were trying to bully me into accepting their claim. Then it was the HOA's turn. Richard Bennett called his surveyor first, a nervous-looking guy named Brad Peters who worked for a firm in Columbia. Under questioning from Bennett, Peters claimed his survey was accurate and that the clubhouse was on HOA land. But when Jennifer cross-examined him, he fell apart quickly. "Mr. Peters, did you personally visit the property to conduct this survey?" Jennifer asked. "Yes, I did." "Did you look for the original survey markers?" "I looked, but I did not find them." "Did you check the county records for the legal description of Mr. Harper's property?" "I reviewed the records that were provided to me by the HOA." "That is not what I asked. Did you independently check the county records?" Peters hesitated. "I relied on the information provided by my client." "So you did not independently verify the property boundaries? You just took the HOA's word for it?" "I performed a professional survey based on the information I was given." Jennifer pulled out Tom Mitchell's survey. "Mr. Mitchell found the original survey markers. They are right where they should be according to the county records." "Why did you not find them?" "I do not know. Maybe they have been disturbed or moved over the years. Or maybe you did not look very hard because you were hired to produce a survey that said what your client wanted it to say." Bennett objected, but the damage was done. It was clear that the HOA's survey was sloppy at best and deliberately biased at worst. Next, Bennett called Patricia Morrison to testify. This was what I had been waiting for. I wanted to see her try to explain under oath how she thought it was okay to build on someone else's land. Patricia took the stand wearing another expensive suit, this one navy blue with pearls. She looked confident, almost smug, like she thought she was going to set everyone straight. Bennett asked her basic questions about the HOA, the decision to build the clubhouse, and the survey they had relied on. Patricia answered smoothly, portraying herself as a dedicated volunteer just trying to improve the community. "Miss Morrison, when did you first become aware that Mr. Harper claimed to own the land where the clubhouse was built?" Bennett asked. "When he called our office shortly after construction began. He was very aggressive and hostile on the phone." I almost stood up to object to that characterization, but Jennifer put a hand on my arm to keep me seated. "And what did you do when he made that claim?" Bennett continued. "I reviewed our records and our survey. Everything clearly showed the land was part of our community common area. I believed then, and I still believe now, that Mr. Harper is simply mistaken about his property boundaries. Perhaps he does not understand how to read a survey, or he has bad information. So, in your professional opinion as HOA president, the clubhouse is on HOA land?" "Absolutely. We would never build on private property without permission. That would be wrong." The irony of that statement was incredible. Then Jennifer got her turn to cross-examine, and the confident facade started to crack. "Miss Morrison, you say you reviewed your records when Mr. Harper called. Did those records include a title search of the land?" "We had the survey." "That is not what I asked. Did you conduct a title search to verify who actually owned the land?" "The survey showed it was HOA land." "Please answer the question yes or no. Did you conduct a title search?" Patricia's jaw tightened. "No." "Did you check the county property records?" "No." "Did you make any effort whatsoever to verify ownership beyond looking at a survey that your own HOA had commissioned?" "The survey was supposed to be accurate, but you did not verify it. You took it on faith and proceeded to build a substantial structure without doing basic due diligence to confirm you owned the land. Is that correct?" "We trusted our professionals." Jennifer picked up a stack of papers. "Let us talk about these letters you sent to Mr. Harper. Starting in September, you began sending him notices claiming he was a member of the HOA and owed dues and fees. Why did you do that?" "Because his property is within our boundaries, so he is subject to our bylaws." "But he never signed any agreement with the HOA, did he?" "When property is within HOA boundaries, owners are automatically subject to the rules." That is not actually how it works, Miss Morrison. You cannot just declare someone is in your HOA because you want them to be. But let us move on. You also sent Mr. Harper multiple violation notices for things like having grass that was too long and storing firewood on his property. Why? We have standards in our community. But he is not in your community. You have admitted you have no agreement with him. So why were you trying to enforce rules on his property? Patricia's face was getting red. He needed to understand that there are standards expected in this neighborhood. Or maybe you were trying to harass him into accepting your claim to his land. Maybe you thought if you sent enough threatening letters, he would just give up and let you keep the clubhouse you illegally built. That is not true, really, because you also threatened to put a lien on his property for unpaid dues that he never actually owed. That sounds like harassment to me. Bennett objected and Judge Henshaw sustained it, but again the point was made. Patricia Morrison looked flustered and angry, which was exactly how Jennifer wanted her to look. "Let us talk about the money," Jennifer said. "How much has the HOA spent on this clubhouse?" "I do not have the exact figures in front of me. Approximately," Patricia hesitated. "Including land preparation, construction, and finishes, probably around $400,000. There was a murmur in the courtroom. That was a lot of money. And how did you fund that construction?" "Through a special assessment on all HOA members." "How much was the assessment?" $5,000 per household. "So you collected hundreds of thousands of dollars from your neighbors to build a clubhouse on land you did not own, without doing basic due diligence to verify the property boundaries. Is that a fair summary?" "We acted in good faith based on the information we had." "But you did not verify that information. You just assumed it was correct and spent nearly $500,000 of other people's money. And now, when it turns out you were wrong, you are fighting to avoid taking responsibility for your mistake." Patricia did not answer. She just glared at Jennifer with pure hatred. "No further questions, Your Honor." The rest of the trial was mostly technical testimony about property law and title issues. Jennifer brought in a title attorney who explained in detail how property ownership worked and confirmed that I had clear, undisputed title to the land. Bennett tried to argue various legal theories about easements and good faith improvements, but none of them held water. After 2 full days of testimony, Judge Henshaw called for closing arguments. Jennifer went first, summarizing our case clearly and concisely. "Your Honor, this is simple. Isaac Harper owns the land. The HOA built on his land without permission. Under the law, the HOA must remove the structure and compensate Mr. Harper for his damages. There is no legal theory that allows the HOA to keep a building they constructed on someone else's property without permission." Bennett's closing argument was desperate. He talked about the good faith of the HOA, the money that had been spent, the disruption to the community if the clubhouse had to be torn down. He asked the court to find some way to let the HOA keep the building, maybe by requiring me to sell them the land, or by granting them an easement. Judge Henshaw listened to everything, took some notes, and then sat back in his chair. "I am prepared to rule from the bench. This case is not complicated, despite the parties' best efforts to make it so. Mr. Harper has clear title to the property in question. The chain of title is unambiguous. The surveys, with the exception of the one commissioned by the HOA, all agree on the property boundaries. The HOA built a structure entirely on Mr. Harper's land without permission. That is trespassing, and it does not matter whether the trespass was in good faith or not." Patricia Morrison made a sound like she had been punched. The HOA's arguments about easements and adverse possession are without merit. You cannot establish an easement by mistake, and the time requirements for adverse possession have not been met. The HOA has no legal right to the land or to the structure they built on it. Judge Henshaw looked directly at Patricia. I am particularly troubled by the HOA's conduct during this dispute. The harassment letters, the violations notices, the threats of liens, all of that was improper and frankly bullying behavior. Mr. Harper was not a member of your HOA and was under no obligation to follow your rules. Your attempts to intimidate him into accepting your claim to his land were inappropriate. He turned back to his notes. I am ruling in favor of Mr. Harper. The court finds that he is the sole owner of the disputed property. The Meadowbrook Hills HOA is ordered to remove the clubhouse structure from his land within 90 days. The HOA is also ordered to restore the land to its original condition, including replanting any trees that were removed. I felt a wave of relief wash over me. Finally, justice. Furthermore, Judge Henshaw continued, the HOA is ordered to pay Mr. Harper's legal fees and costs, as well as compensatory damages for trespass. The parties can submit proposed damage calculations within 30 days, but I am inclined to award at least $50,000 for the trespass itself, plus the cost of land restoration. Patricia stood up. Your Honor, this is outrageous. We acted in good faith. You cannot expect us to tear down a $400,000 building. Miss Morrison, sit down, Judge Henshaw said sharply. You built on land you did not own. The consequences of that mistake are yours to bear. If you had done proper due diligence before construction, this would never have happened. But you did not, and now you have to deal with the results. But the community members who paid for this should be very angry with their HOA board for wasting their money. Court is adjourned. The gavel came down, and it was over. I had won. Patricia Morrison stormed out of the courtroom without looking at me, Bennett hurrying after her. The HOA residents who had been watching looked shocked and angry. I heard muttering as they filed out, words like unbelievable and how could they screw this up so badly. Jennifer shook my hand. Congratulations. That was about as complete a victory as you can get. So now what? They actually have to tear it down. They do. 90 days to remove it, or we can go back to court and ask for contempt sanctions and daily fines until they comply. Plus they owe you damages and legal fees. I will draft up the proposed amounts this week. I walked out of the courthouse feeling vindicated but also exhausted. This had been going on for months, consuming my time and energy and causing constant stress. At least now it was resolved. Except Patricia Morrison was not done yet. 3 days after the judgment, I got a certified letter from the HOA. It was not an apology or an acknowledgement of the court's ruling. Instead, it was a notice that the HOA was appealing Judge Henshaw's decision to the South Carolina Court of Appeals. I called Jennifer immediately. Can they do this? Just drag this out forever with appeals? They can appeal, but it is not going to change anything. Judge Henshaw's ruling was based on clear property law. An appeals court is not going to overturn it. But yes, this will delay things. An appeal could take 6 months to a year. So the clubhouse just stays there. For now, yes. They do not have to comply with the removal order until the appeal is exhausted. But Isaac, they are throwing good money after bad. Appeal costs money and they are not going to win. So why do it? Pride, probably. Patricia Morrison cannot admit she was wrong. She would rather keep fighting than face the consequences. The appeal process was even more frustrating than the trial because there was nothing to do. No more hearings, no more testimony, just waiting while lawyers filed briefs and the appeals court reviewed the record. Jennifer filed our response brief arguing that there were no grounds for appeal, but then we just had to wait. Meanwhile, life in the neighborhood got weird. Word spread quickly about the trial outcome, and apparently there was a major revolt happening within Meadowbrook Hills. I heard from Derek, who heard from someone who lived in the development, that residents were furious. They had paid $5,000 each for a clubhouse that now had to be torn down, and they wanted answers. An emergency HOA meeting was called. I obviously was not invited, but Derek's friend went and reported back. Apparently it was chaos. Residents were screaming at Patricia Morrison and the rest of the board, demanding to know how this happened and why they had not done proper research before building. There were calls for the entire board to resign. Patricia, according to the reports, refused to take responsibility. She blamed the surveyor, blamed the construction company, blamed me for being unreasonable, blamed everyone except herself. She insisted that the appeal would succeed and that the clubhouse would be saved. But even within the HOA, support for the appeal was crumbling. Several residents stood up and said they should just accept the judgment, tear down the clubhouse, and try to recover some money by suing the surveyor or whoever else had given them bad information. Fighting further was just wasting more money on legal fees. A vote was called on whether to continue the appeal. Patricia pushed hard for it, saying they had to fight for the community, but the vote failed. The majority of residents wanted to cut their losses. Except Patricia Morrison had already filed the appeal in the HOA's name, and according to the bylaws, the president had authority to make legal decisions on behalf of the association. She announced that regardless of the vote, she was continuing the appeal because she believed it was in the community's best interest. That led to another vote, this one to remove Patricia as president. It passed overwhelmingly. Patricia was out, replaced by a man named Gerald Foster who seemed much more reasonable. Gerald called me a week later. "Mr. Harper, my name is Gerald Foster. I am the new president of Meadowbrook Hills HOA. I want to apologize for everything that has happened and discuss how we can resolve this situation." Finally, someone with sense. "I appreciate that, Mr. Foster. What did you have in mind?" "First, we are withdrawing the appeal. That should be filed with the court by the end of the week. Second, we accept Judge Henshaw's ruling and will comply with the removal order. Third, we would like to discuss whether there is any possibility of purchasing the land from you so we can keep the clubhouse." "I am not interested in selling," I said immediately. "I understand. But perhaps you would consider it if the price was right. We have already spent $400,000 on the building. Tearing it down is just destroying that investment. If we could buy the land from you, even at a premium, it would save the community money." I thought about it. Part of me wanted to just say no out of spite, but the practical part of me recognized that I had never actually planned to use that back land for anything. And if they were talking about paying a premium, what kind of price are we talking about? The land is probably worth $50,000 or $60,000 based on comparable sales in the area. We would be willing to pay $200,000. That got my attention. $200,000 for land I was not using, plus the $50,000 or so in damages I was already getting from the court judgment. That was a lot of money. "Let me think about it and talk to my lawyer," I said. I discussed it with Jennifer that afternoon. "It is a good offer," she said. "Well above market value, and it solves a lot of problems for everyone. You get paid, they get to keep their clubhouse, and this whole mess ends. But they are the ones who screwed up. Why should I make it easy for them?" "Because you will walk away with $250,000 for land you were not using. That is a win, Isaac. Yes, you could force them to tear down the clubhouse out of principle, but what does that actually gain you? The land will be restored, sure, but then it is just sitting there empty like before. This way you profit significantly from their mistake. She was right. I was angry about how I had been treated, but forcing them to demolish a perfectly good building just out of spite was not going to make me feel better. And $200,000 would make a huge difference in my life. I could pay off my mortgage, fix up the house, maybe finally take that trip to Alaska I had been dreaming about. Okay, I said, but I want the money up front, and I want a written apology from the HOA acknowledging they were wrong. Gerald Foster agreed to both terms. The HOA held another special assessment, this one for $2,000 per household, to raise the money to buy my land. Apparently there was some grumbling about having to pay more money after already paying $5,000 for construction, but most residents agreed it was better than paying to demolish the building and having nothing to show for any of it. The closing was scheduled for 3 weeks later. In the meantime, Jennifer worked out the final details of the settlement. In addition to the $200,000 for the land, the HOA paid $50,000 in damages, plus $30,000 for my legal fees. They also agreed to withdraw the appeal and sign a settlement agreement that fully resolved all claims. The written apology came from Gerald Foster on behalf of the HOA board. It was actually pretty thorough, acknowledging that the HOA had built on my land without permission, had not done proper due diligence, had harassed me with improper violation notices, and had handled the entire situation poorly. It did not specifically name Patricia Morrison, but everyone knew who was really responsible. The day of the closing, I met Gerald and the HOA's attorney, not Richard Bennett, but a new lawyer they had hired, at a title company office in Greenville. We signed all the papers, and I walked out with a check for $280,000, all damages and fees included. I really am sorry about how this went down, Gerald said as we shook hands. Patricia had gotten very difficult in the last couple years. A lot of us on the board went along with her decisions because it was easier than arguing. We should have pushed back on the Clubhouse project until proper due diligence was done. What happened to her? I asked. She resigned after being removed as president. Some of the HOA members are talking about suing her personally for mismanagement, but I do not think it will go anywhere. Mostly people just want to move on. I ran into Patricia Morrison one more time, about a month after the closing. I was at a grocery store in Greenville, and I saw her in the produce section. She saw me too, and for a moment we just looked at each other across a display of apples. I expected her to turn away or pretend she had not seen me. Instead, she walked over, her face tight and controlled. "I hope you are happy," she said. "You got your money. I got compensation for land that was mine, land your HOA built on without permission. We made a mistake. We relied on professionals who gave us bad information. That survey company has since lost their license, by the way. But you could have been reasonable. You could have worked with us instead of dragging us through court and costing the community hundreds of thousands of dollars." I felt my anger rising again. Even now, even after everything, she could not take responsibility. It was still everyone else's fault. "I did not build on your land, Patricia. You built on mine. I did not start this fight. You did, and then you doubled down by harassing me and refusing to admit you were wrong. Even after a judge told you that you were wrong, you kept fighting. So no, I do not feel bad about how this turned out. You did this to yourself and your community." Her face flushed red. "You are a selfish, petty man. That clubhouse would have benefited the entire neighborhood, increased property values, created a gathering space for families. But you cared more about your pride than about the community." "It is my land," I said, loud enough that other shoppers turned to look. "I do not care what you wanted to build on it. It is mine. You do not get to just take what you want because you think your plans are more important than property rights." Patricia opened her mouth to respond, then seemed to think better of it. She turned and walked away, her cart rattling across the floor. I stood there shaking with adrenaline. Even months later, she could still get under my skin. But as I calmed down, I realized I did not actually care what Patricia Morrison thought. I had won. The law had been on my side, and I had nearly $300,000 in my bank account as proof. I deposited the settlement check, paid off my mortgage like I had planned, and set aside money for renovations. The house my grandfather had left me was solid but outdated, and I had always wanted to update the kitchen and bathrooms. Now I could afford to do it right. I also started looking into what to do with the rest of the money. Derek suggested investing it, building up a retirement fund. That made sense, but I also wanted to do something meaningful, something that honored my grandfather's memory and the land he had left me. I ended up using $50,000 to establish a small conservation easement on some wetlands that bordered my property. It was not part of the land I had sold to the HOA, but a different section near the creek. The easement would preserve it permanently, preventing development and protecting the habitat for the birds and wildlife that lived there. Grandpa had always loved nature and had taught me to appreciate the land. This felt like the right way to honor that. The clubhouse opened for Meadowbrook Hills residents about 2 months after the closing. They had to finish some interior work that had been delayed during all the legal fighting. I heard it was actually pretty nice, with a gym, a party room, and a kitchen. Good for them. It was on their land now, legally and properly, and they could enjoy it. I never did join the HOA, despite Gerald Foster jokingly suggesting that since they now owned land adjacent to mine, maybe I would want to reconsider. I politely declined. I had had more than enough of HOA drama for one lifetime. Life returned to normal, or as normal as it could be after months of legal battles. I went back to focusing on my work as an electrical engineer, spent weekends fixing up the house, and tried to put the whole clubhouse nightmare behind me. But the story was not quite over yet. About 6 months after everything was settled, I got a call from a reporter at the Greenville News. Apparently, the story of the HOA building on the wrong land had caught the attention of someone at the paper, and they wanted to write an article about it. I was hesitant at first. I did not want to reopen old wounds or deal with more drama. But the reporter, a woman named Sandra Chen, convinced me that it was an important story about property rights and HOA overreach that other people could learn from. I agreed to an interview. Sandra came to my house, took some photos, and asked detailed questions about everything that had happened. She also interviewed Gerald Foster and several other Meadowbrook Hills residents, and she apparently tried to reach Patricia Morrison, who refused to comment. The article ran a few weeks later as a front-page story in the local section. It was fair and balanced, laying out the facts of what had happened without editorializing too much. But the headline said it all. HOA built clubhouse on wrong land, cost members hundreds of thousands. The story got picked up by some state and regional news outlets. I did a couple more interviews, including one with a local TV station. Suddenly, I was the guy who had stood up to an overreaching HOA and won, which was kind of surreal. The attention brought out both supporters and critics. I got emails and social media messages from people praising me for defending property rights and standing up to the HOA. I also got angry messages from some Meadowbrook Hills residents who blamed me for the whole mess and the money they had to pay. One email in particular stood out. It was from a woman named Wendy Klein who lived in Meadowbrook Hills. She wrote that she had been one of the residents pushing for Patricia Morrison to be removed as president after the trial, and she thanked me for not backing down. Patricia had turned the HOA into her personal fiefdom, Wendy wrote. She made decisions without consulting anyone and shut down anyone who questioned her. The Clubhouse disaster was just the most obvious example. She had been pulling stuff like this for years, just on a smaller scale. Your lawsuit finally exposed what she was doing and gave the rest of us the ammunition we needed to take back control of our HOA. That made me feel better about the whole situation. I had not been trying to hurt ordinary homeowners. I had just been defending what was mine. If my case had helped reasonable people push out a bad HOA president, that was a silver lining. As the months went by and the media attention faded, life truly did return to normal. I finished the kitchen renovation and started on the bathrooms. I took that Alaska trip I had been dreaming about, spending 2 weeks hiking and fishing and enjoying the wilderness. It was restorative after all the stress. I also started dating someone, a woman named Michelle I met through a friend. When I told her about the HOA saga on our third date, she laughed so hard she nearly spit out her wine. "Only you," she said. "Only you could end up in a situation that crazy." It was not my fault. I know. But seriously, what are the odds? They built an entire building on the wrong land. How does that even happen? I had asked myself that question many times. The answer, I eventually realized, was a combination of incompetence, arrogance, and a lack of accountability. The surveyor had done sloppy work. Patricia Morrison had been too arrogant to double-check it. The rest of the HOA board had been too passive to push back. And the system had allowed all of that to happen without any checks, until it was too late and hundreds of thousands of dollars had been wasted. It was a cautionary tale about what happens when HOAs are run by people who care more about control than about doing things right. A year after the settlement, I got one more piece of news about the saga. Jennifer called to tell me that several Meadowbrook Hills residents had indeed sued Patricia Morrison personally for negligence and breach of fiduciary duty in her role as HOA president. They were seeking to recover some of the money that had been wasted on the Clubhouse debacle. "Do you think they will win?" I asked. "Maybe. It depends on a lot of factors, including whether Patricia has personal assets worth going after and whether the HOA's insurance will cover any of it. But the fact that they are suing at all says something. Usually HOA members just eat the loss and move on. But this was such an egregious screw-up that people want accountability." I did not follow the lawsuit closely, but I heard through the grapevine that it eventually settled for an undisclosed amount. Patricia Morrison and her husband reportedly had to take out a second mortgage on their house to pay their share of the settlement. I did not take any pleasure in that, but I did not feel sorry for her either. Actions have consequences. As I sit here now, 2 years after this whole thing started, looking out at my newly renovated kitchen and the peaceful backyard beyond, I think about what I learned from the experience. I learned that you should never assume people in authority know what they are doing or have your best interests at heart. I learned that standing up for yourself, even when it is hard and expensive and stressful, is sometimes necessary. And I learned that property rights matter, even when it would be easier or more convenient to ignore them. Most importantly, I learned that my grandfather had given me more than just land when he left me this property. He had given me roots, a connection to the past, and something worth fighting for. I hope I honored his memory by defending what he left me. The clubhouse still stands on what is now HOA land, and from what I hear, it gets decent use from Meadowbrook Hills residents. Kids have birthday parties there. The HOA holds meetings there. People work out in the gym. So in the end, it serves the purpose it was meant to serve, just not in the way Patricia Morrison originally planned, and me. I am just living my life, grateful for the peace and quiet of my little 3 acres in Greenville, South Carolina. Well, 2 acres now, but who is counting? I have my house, my job, my girlfriend Michelle, who thinks my HOA story is hilarious, and enough money in the bank to feel secure and comfortable. Sometimes I walk out to the edge of my property, to the new boundary line that separates my land from the HOA land where the clubhouse sits. I look at that building and remember all the stress and anger and frustration it caused, but mostly, I feel grateful. Grateful that I stood up for myself. Grateful that the legal system worked the way it was supposed to. Grateful that justice was served. And grateful that I never, ever have to deal with Patricia Morrison or her HOA again. The whole experience taught me something valuable about the nature of property ownership in America. We have laws and systems in place to protect individual rights, but those laws only work if people are willing to stand up and enforce them. If I had backed down when Patricia Morrison told me I was wrong about my own property boundaries, if I had accepted the HOA's claim rather than fighting it, they would have gotten away with it. The clubhouse would still be there, but it would be there because I had been too intimidated or too exhausted to fight back. That is how rights get eroded. Not through dramatic government overreach, but through small acts of bullying and intimidation that go unchallenged. Patricia Morrison thought she could push me around because she was used to getting her way. She had probably done it to other people before, on smaller issues, and they had backed down. But this time she picked the wrong property and the wrong person. I also gained a new appreciation for good lawyers. Jennifer Caldwell earned every penny I paid her, and then some. She understood the law, she understood strategy, and she understood how to fight effectively against an opponent who had more resources. Without her, I might have won eventually, but it would have taken longer and cost more. The financial windfall from the settlement changed my life in concrete ways. Beyond paying off the mortgage and renovating the house, I was able to finally build that workshop I had always wanted, just on a different part of my property. I set it up with good tools and equipment, and now I spend my weekends out there working on projects, building furniture, fixing things. It is therapeutic, working with my hands and creating something tangible. I also donated some money to local conservation causes, organizations working to preserve green space and natural habitat in the Greenville area. It felt right to use some of the money that came from that land dispute to protect other land from development and destruction. Michelle and I got more serious over time. About a year into our relationship, she moved into the house with me. She loved the property as much as I did, and she brought her own ideas for gardens and landscaping that have made the place even more beautiful. We talk sometimes about maybe getting married someday, building a life together here on this land my grandfather left me. One evening, we were sitting on the back porch watching the sunset when Michelle asked me if I ever regretted selling that 1.5 acres to the HOA. No, I said, and I meant it. I would have regretted letting them push me around. I would have regretted not standing up for what was mine. But once I won and made them acknowledge that they were wrong, selling the land was the smart move. I got paid way more than it was worth, and they got to keep their building. Everyone ended up better off than if they had just torn it down. Even Patricia Morrison, I laughed. Well, maybe not her, but that is her own fault. The sun dipped below the horizon, painting the sky in shades of orange and purple. Somewhere in the distance, I could hear voices and laughter from the clubhouse. The HOA was having some kind of event. I felt no bitterness about it, no resentment. They were welcome to enjoy their facility on their land, and I was welcome to enjoy my peace and quiet on mine. That is how the story ends, not with anger or bitterness, but with satisfaction and peace. I stood up for my rights. I fought the battle that needed to be fought, and I won. Justice was served, I was compensated fairly, and life moved on. In the end, that is all anyone can ask for. The legal precedent from my case apparently has been cited in a few other property disputes in South Carolina. Jennifer told me that at least 2 other people have contacted her about similar situations where HOAs or developers encroached on their land, and they used my case as a template for how to fight back. That makes me proud. If my experience helps other people defend their property rights, then all the stress and hassle was worth even more than I thought. I sometimes wonder what would have happened if I had not noticed the construction that morning when I was drinking my coffee. What if I had been traveling for work? Or what if the trees had been thicker and I had not seen the activity? Would the clubhouse have been completed and in use before I even realized it was on my land? Would it have been harder to fight at that point, with the building finished and HOA members using it? Probably. Timing mattered. I caught it early enough that I could stop construction and force the issue while it was still fresh. If months or years had passed, the HOA might have had stronger arguments about reliance and investment. I got lucky in that sense, but luck only goes so far. I still had to make the decision to fight, to hire a lawyer, to invest the time and money and emotional energy into the battle. A lot of people would have looked at the situation and decided it was not worth it. They would have negotiated some kind of compromise early on, maybe sold the land for less money just to make the problem go away. I do not blame anyone who would have made that choice. Legal battles are exhausting and uncertain, and not everyone has the resources or temperament for them. I am glad I fought, though. Not just because of the money, but because it was the right thing to do. Property rights mean something. The law means something. And people like Patricia Morrison need to learn that they cannot just take what they want, because they think their plans are more important than other people's rights. As I finish telling this story, sitting here in my renovated kitchen with Michelle making dinner and the evening light streaming through the windows, I feel content. The house is mine, truly mine, with no mortgage hanging over it. The land is mine, protected and preserved. And I have the knowledge that I stood up for myself when it mattered and won. That clubhouse saga was one of the most stressful periods of my life, but it also taught me a lot about myself. I learned that I am tougher than I thought, more willing to fight when necessary. I learned the importance of documentation and preparation. I learned that the legal system, for all its flaws, can work when you have the law on your side and the determination to see things through. And I learned that sometimes the worst experiences lead to the best outcomes. If the HOA had never built on my land, I would still be living in the same house with the same mortgage, probably still talking about someday renovating the kitchen. The conflict forced changes that improved my life in ways I never would have pursued otherwise. So in a strange way, I should maybe thank Patricia Morrison. Not for what she intended to do, which was to steal my land and bully me into accepting it, but for inadvertently providing me with the opportunity to stand up for myself, to fight a battle worth fighting, and to come out the other side stronger, wealthier, and more confident than before. Life is funny that way. The obstacles that seem insurmountable in the moment often turn out to be opportunities in disguise. The key is having the courage to face them head-on rather than backing down or running away. That is my story. The story of how an HOA built a clubhouse on my land, how I fought back with the deed in my hand and the law on my side, and how justice ultimately prevailed. It is not a story about revenge or anger. It is a story about property rights standing up for yourself, and the importance of doing things right the first time. If there is a lesson in all of this, it is probably this: do your homework. Whether you are building something, buying something, or claiming something, make sure you actually know what you are doing and that you have the right to do it. Patricia Morrison and the Meadowbrook Hills HOA learned that lesson the hard way, at a cost of hundreds of thousands of dollars and immeasurable embarrassment. I learned my own lessons too. I learned that having the deed to your property is not enough if you are not willing to defend your ownership when it is challenged. I learned that bullies, whether individuals or organizations, will keep pushing until someone pushes back. And I learned that sometimes the right choice is also the hard choice, and you have to be willing to accept the difficulty to get the right outcome. 2 years later, life has settled into a comfortable rhythm. The drama is behind me, the legal battles are over, and the settlement money has been well spent on improvements and investments that have made my life better. Michelle and I are talking about maybe starting a family someday, raising kids on this land that has been in my family for decades. When that day comes, I will have stories to tell them. Stories about their great-grandfather who bought this land and built the house. Stories about growing up visiting this place, learning to appreciate nature and hard work and property. And yes, stories about the time an HOA tried to steal part of their inheritance and how their father fought back and won. Those stories will teach them the same lessons my grandfather taught me, and that this whole experience reinforced. The land matters. Rights matter. Standing up for yourself matters. And sometimes you have to fight for what is yours, even when it would be easier to walk away. That is the legacy I want to pass down, along with the property itself. Not just the physical land and the house, but the values and lessons that make them meaningful. So here I am, Isaac Harper, living in Greenville, South Carolina, on land that my grandfather left me and that I successfully defended against an overreaching HOA. The clubhouse stands next door on property that is now legally theirs, paid for at a premium that compensated me fairly for their mistake. Justice was served, lessons were learned, and life goes on. And every morning when I drink my coffee and look out at my backyard, at the trees and the creek and the workshop I built, I feel grateful. Grateful for what I have, grateful for what I fought for, and grateful for how everything turned out. That is the end of my story. The story of the HOA that built a clubhouse on my land, and how I showed up in court with the deed and won everything I deserved. It is a true story of property rights, legal battles, and the importance of standing your ground when you know you are right. And every single day, I am glad I fought that fight.